Hello, it's Jenkins, the family law vlogger here. This is the next vlog in the series on pensions, and this one is about the orders that a court can make in relation to pensions. So the first thing to notice, we are talking about pensions on divorce. So the law relating to pensions when a couple are cohabiting and aren't married is different. So what orders can a court make? So the first and most common order is called a pension sharing order. So in a pension sharing order, whether it's ordered by a court because the court's decided that's the appropriate thing, or because a couple have agreed this approach, perhaps in mediation or collaborative law, what the court can order is that a percentage of the first person, let's call them person A's pension, is transferred into a pension for person B. So important things to note are, it has to be a percentage. So say person A has a pension worth £300,000 and they've agreed that person B will get approximately £150,000 from that pension to go into person B's pension. It's the percentage that can appear in the order, and it's the percentage that the pension company will then act on to implement the order. So yes, whilst the calculation can be based on, well, person B is receiving about £150,000 from person A's pension, the pension sharing order itself won't actually be implemented for several months after the order's made. So by then the pension of person A may have gone up, and so 50% might be more, or it might have gone down and 50% might be less than the 150,000 person B was expecting. But that's the way the law is, it has to be a percentage. So that then is the pension sharing order. Second approach to pensions is something called offsetting. So when you're looking at a sort of overall package of outcomes for a couple on a divorce, you often have a range of assets. So there's pensions there's often a house, there's often other assets, whether that's a business or investments or ISAs or other savings. Offsetting is whereby one person keeps all or most of their pension, but in return, the other person gets more of the other assets. So for example, in our scenario of person A having a pension worth £300,000, person B might get nothing from that pension, but the overall package that court thinks is reasonable, or the couple decide on advice is reasonable, is for person B to say get more of the value of the house or more of other investments. So that's offsetting. A word of warning about offsetting. £1 of pension is not normally taken as the equivalent of, say, £1 in the value of a house or £1 in the value of cash in a bank. That's because pensions are tied up. There's lots of restrictions about when you can withdraw money from pensions and how you can deal with them. And so £1 in the bank that you can actually spend and is liquid is probably worth more in some terms than £1 of pension. So that's where, if you're considering offsetting, the advice of a pension expert called a PODE, P-O-D-E, which we'll look at in a separate vlog, is really, really important. But that's the second type, is offsetting. The third type that we come across sometimes, but it's now pretty rare, although they were much more common when pension orders were first allowed many years ago, is called a pension attachment order. And with a pension attachment order, instead of taking a percentage out of person A's pension and putting it into person B's pension, the pension attachment order means that person B would get some of person A's benefits when they actually retire. So it's a very different scenario in that you might do the deal now, there might be an agreement that person B will get certain benefits when person A retires. But if that doesn't happen for 15 years, for example, then it can be quite a delay before that benefit comes through. And there's a real risk for person B that person A dies in that 15 years time, and then the pension and the pension attachment order dies with them, so person B can be left vulnerable. It also means that the couple are tied together for the long term. It's not a clean break. Whereas because they're waiting to get their share of the pension by a pension attachment order at some point in the future. Whereas the first option, a pension sharing order, once it's implemented a few months after the order is made, does mean there's a clean break and the parties can get on with their lives, provided that there's no maintenance ongoing as well. So those are the three key areas. There's pros and cons of each. Most common is pension sharing order. Often there's offsetting as an alternative. Pension attachment orders I mentioned because it is a possibility, but it's pretty unusual. As always with the Family Law Vlog, if you need any advice about your specific circumstances or have any queries, whether about pensions on divorce, separation or otherwise, then please do contact me or one of my expert colleagues in the Mills Reeve Family and Children team, and we'll be happy to help you.